Hello, everybody. Welcome once again to the Hines webinar series. I shouldn't be scratching myself at the start there. Right, I'll stop doing that. Our regular deep dive into the wonderful and weird, let's face it, world of strata and management rights in Queensland. So I am Chris Irons and I'm the director of Strata-Solve, stratasolve.com.au. For those of you out there taking notes, and as always, Frank Higginson, partner Hines Legal, and Hines is the premier provider of legal advice to the strata industry in Queensland. Hello, Frank.
Hello, Chris. I never get sick of hearing you say that. Hello, everyone. Yet again, we're back and you're here with us. And look, in all seriousness, thanks very much, everyone, for making the effort. There's any number of ways you can consume this kind of information. We're glad that you've chosen this one. Look, today we're talking about, look, it's a big topic, this one. Lots of buttons being pushed very hotly in this topic, Frank. Defamation. Defamation in strata. Before we get to the nuts and bolts of that, and there is a lot of nuts and bolts to cover on that one, housekeeping. For those of you listening live on YouTube, post your questions in, and we'll try and welcome those so long as we can actually get to them. If you're listening in later on, say you're out walking the dog or washing the car or whatever it is that you're doing, you can find all the notes and the links that we spoke about at hineslegal.com.au. That'll all be available after the event. So yeah, defamation, Frank. It's a big thing, isn't it? It's a huge thing. You know, and it's been huge in the media in recent times as well. I mean, you look at anyone who's followed any of and I suppose it's in the media because they're normally the ones that are doing the alleged defaming. Ben Roberts-Smith, you look at Clive Palmer versus Mark McGowan, you know, so that was a epic proceeding that ran for weeks and I think resulted in total judgment of about 15 grand, 10 one way, 5 the other, and who knows how many $1 million spent on legal fees. So Jeffrey Rush, there's lots of sort of big names that have lurked around. And for me, it comes up quite a bit in strata, and we'll get to that. So this really, there is definitely a strata component to what we're talking about today. But the defamation, the whole industry of defamation in itself, I suppose there's some basics, but I'm not going to go into so I suppose I might disappoint a few people here. If you've tuned in or you're listening to try to figure out how it is that you start your own defamation proceeding, how much money you're going to make off someone calling you a name you didn't like, then today is not for you. So I think it's to do some basics. Let's talk about what it really means in context of strata. And again, mate, as always, some best practice type stuff.
Well, I mean, Frank, why would you say all that? I mean, you don't work for free.
No, they're not nice matters to have. Is the reality, and I think, and I was going to save this anecdote for the end, but I'll bring it up the front. So I get quite a lot of phone calls and emails from people that say they've been defamed.
Yeah,
happens once a fortnight, maybe once a week if I'm unlucky. Or the clients are unlucky, and this is what's happened, Frank, and here's this correspondence, and they're upset and they're angry, and I get it. Because someone said something about them that isn't necessarily nice. And the reality is that happens about me too. You know, I've had clients email me and say, you know, because unfortunately, as much as I'm more of a lover than a fighter, our role sometimes is adversarial. We act for clients against other people. And that sometimes involves a degree of sort of, I suppose, figurative punchiness. So we might make demands of people. We might tell people they've done the wrong things. We might require them or demand that they do something else that they want to do. So clients will email me and say, look what they just said about you. It's like, well, that's fine. Whatever, water off a duck's back. But when clients ring me and say, this is what they've said, my first reaction always is, here's the good news. You've got 12 months to do something about it. There's the first little bit of legal advice today from defamation. You've got 12 months to do something about it. But short of it being something completely outrageous, how about you leave it sit for a week? Leave it sit for a week. Then let's have a chat and see whether anything's come of it. And every single time I've had that conversation, nothing's come of it. because it's all hot and heavy at the time. And absolutely, I could punch out concerns, notices and demands and threats and that sort of stuff the next day, and everyone gets wound up. But a week later, it is dead set forgotten. Because I think what people lose track of in strata and maybe even life, like in terms of if you're a committee and I'm a resident manager, Chris, and we don't like each other and we've got a community of 50 owners and we're having a little head-to-head internally and we're writing to all the owners. My experience in strata is that the bulk of owners switch off really quickly, something like that, to the extent they even switch on in the first place. Delete. So our blue, as much as it might be the most important thing to you and me, probably has maybe another 8 to 10 people actually even remotely interested in what's going on.
Yeah, I think that's all really well said, Frank. I mean, I've lost count of the number of times I've been called all sorts of things.
Well, as a commissioner, you would have copped it a bit too, wouldn't you?
I was called creeps all the time, but that you can let that go most of the time. But there are times when people say stuff like that, and it becomes personal because you think to yourself, "I'm doing this job, and you're claiming that I'm doing it for all the wrong reasons, and you've never met me in your life." But is firing off a concerns notice the way to deal with that? No, it's not. But anyway, we'll sort of get into that philosophical side of things a bit more. We're going to put up a link now, and this isn't a link about a particular strata defamation case that was very, very topical and in the headlines just a couple of years ago. And it's from Sydney, but very relevant to our purposes here. And I think in this case, you'll be able to see that a tenant, so not even an owner, but a tenant, said some choice words about a committee member in an email, and then had a $120,000 defamation judgment against them, which was, there was an appeal, which was set aside. But even so, gee, that's...
how many years and how many dollars? Was that worth it? No, is the answer.
But I think, Frank, the bottom line out of that is that you must be seeing a fair bit of it from your part of the world.
Yeah, and we tend to talk people off the ledge a lot. And actually someone who might be listening, Chris, I know he's a fan of both you and I, rang me with one of these and I sat him down for a coffee and explained how it worked. And a week later he said, "You know what, you're right. What does your wife like to drink?" And so I had a nice bottle of gin delivered out of that. So it's just, I really do think in terms of stuff you want to spend your money on, it's not this if you can avoid it.
Yeah.
So, sorry, mate.
Yeah. No, you're right. Well, let's rip into it then, Frank. When we say defamation, what are we actually talking about?
Well, in a strict legal definition, this is as close as I'll get to doing the law stuff today, it's a publication published to a third party. So it's not me writing to you saying you're an idiot. It's me writing to a bunch of people saying you're an idiot. That publication needs to identify you. It's not there's a person on the committee. It's this Chris Irons on the committee, and he's an idiot. And the imputations or the statements in that publication have got to be defamatory to the extent that it sort of lowers people's opinion of you in the estimation of others. So
I have to chuckle at that one, Frank, because that presumes you have a reputation that isn't already rock bottom to begin with.
Life is always relative, isn't it? And this is the thing. So the interesting thing with defamation, and this is close as I get to being a constitutional lawyer as well, is that the way our systems of laws work is our federal constitution says the federal government legislates these things, and if it's not in that, then the states get to do it. So the only way the states actually, and that's why we've got different criminal codes. Every state has its different criminal law system. So there's federal laws which relate to things in the federal constitution, and then everything else is state-based, except when the states get together and agree on a national framework of legislation. So they've done that with work health and safety, and they've done that with defamation. And I suppose that's because, if the Courier Mail publishes something, or the Australian publishes something, or to be fair, the Sydney Morning Herald publishes something that goes across the country. So it's not a state-by-state thing. So we have a national framework of defamation laws. So they're the same across all the states. And there's a new piece to it that's just come in, I think probably 12 months ago now, that says that the defamatory matter has caused or is likely to cause serious harm
Uh,
the reputation of that person. So does calling you an idiot cause you serious harm? Probably not. And the interesting thing is, from a legislative perspective, they haven't really defined that. So we're looking offshore at what that means, and it's probably relative to value and size and all that sort of stuff. So that's probably the next round of defamation law, but that's the threshold you need now for something to be defamatory. And then there's a bunch of defences you can have to defamation. So, the first one is obviously it's true. If you write to a committee and says, well, that Frank Higginson has been convicted of trust account fraud, and I have been convicted of trust account fraud, and not that I have, everyone. Saying I've been convicted of
everyone out there has just thought, oh, huge, shocking revelation, but no.
That would be defamatory if it wasn't true.
Yeah.
If it is true, then don't worry about it. It's okay. So that's the core element of defamation. Those things: publication to third parties, which is known, which causes that serious harm. So that, in the essence of it, there's that. And to actually trigger any defamation procedure, you've got to issue a concerns notice. So that's not a demand. There's a very strict structure for them. It's not, you've defamed me, I want an apology. There's a process. You've got to say certain things. You've got to identify the harm that's been caused. You've got to set out the imputations. And you've got to do that before you can commence a proceeding. So that's the 101. And as much as I'm going to talk about what the legal position is today, because from a strata perspective, and I suppose this is what we're talking about, it happens a lot.
So just to pick up on one of those points, your very first one there, you talked about how it's got to be a publication published to a third party. So you look at that in strata, and the really obvious example that springs to my mind is I'm an owner and I am displeased with the actions of a committee member, and my publication to a third party is to all other owners, perhaps. That would be a fairly common one, I'm guessing.
Absolutely. It'd be a comment on a Facebook group where everyone participates. Other ones you see, it's a motion. Someone puts in a motion to, and again, this is the way it works, is people have the ability to put motions into the body corporate before the end of the financial year. And if it's in, it's got to go on the agenda. The body corporate doesn't have a choice. Now, there is then I'll put up an old newsletter where you can discount some material if they're not motions as much as statements. But you can have any sort of material go in, and the body corporate then at law is obliged to publish it, which is send it to the agenda to all owners. So I think Frank Higginson should never be on the committee again because of blah, blah, blah. That's more a statement. It's an opinion. Owners might be able to vote on it. It might not be enforceable, but in theory, it's going to go out to all owners, isn't it?
Absolutely it is. And so looking at a couple of other of those points, the publication must identify the person said to be defamed. So like you said before, Frank, some vague comment about someone on the committee has got their hand in the till. Well, that of itself might be pretty problematic, but you haven't identified anyone. Must lower their estimation, lower their reputation and others. What is serious harm? That's an interesting one in strata, the serious harm one, isn't it?
Reputationally, or is it financially? Is it emotionally? Is it sort of relative value? Is it, I really value my role as a chairperson. That's going to prevent me from getting it. But is that going to cut it from a court perspective and justify the litigation?
There might be one that kicks in a fair bit for strata managers, Frank, that one. So if something is said published to a third person and suggests that the strata manager can't do their job or has taken money or something along those lines, is the serious harm there to their ability to acquire more clients in the future?
And there's carve-outs too from a company perspective. You've got more than 10 employees, you're really sort of not part of this. So if it's an individual strata manager, or is it the employee of the strata manager? It's sort of that Frank Higginson of Iron Strata Management. He's an idiot bloke, and the company's even worse. Maybe the company can't be defamed, but I can be. So it gets really, and this is the thing, I suppose, and we talk about this all the time, is that strata relationships aren't necessarily purely business ones. They're emotional ones. They're your homes, they're your investments, and there's all these little snipey personal things that can really escalate, reply all, late night emails, alcohol, perfect mix.
Yeah, you're right, Frank. That's why think that's why sort of defamation strata is becoming more and more kind of intensive and serious. All the views are held really strongly. I mean, how many times, Frank, have you and I encountered somebody, whether it be a client or someone on the other side, who in every other sense of their life is a smart, successful professional who's achieved amazing things in their personal and professional life, but put them in a strata meeting and suddenly they lose all semblance of control.
Yep. Yep. Yep.
It just so happens so often, that sort of stuff. I think other thing, one of the other things to think about here is that when you think about strata, things get decided according to very specific and very strict deadlines. They also get decided as a group. And so for people who might want things decided quickly, that's a really frustrating thing to have happen. So you want something done quickly, but for a strata committee, it's 6 weeks. Plus another 6 weeks potentially. So suddenly there's this really strong sense of frustration. That in turn can lead somebody to say something and publish something which maybe they should not have done or they would not do otherwise. Yeah.
People vent, and that can lead to accusations about this sort of stuff.
That's right. We covered a few examples before. A couple of other examples might be something said in an email to or from the committee, or to or from a contractor or strata manager. So remember those sorts of things, and this all comes back to body corporate records, of course, which we've banged on about endless number of times in these webinars, and we're going to bang on about that in a minute here too. Every bit of exchange between people involved in the body corporate is very likely going to be a record. Why is that relevant here, Frank? Well, because the record is then open for inspection and copy, isn't it?
Yep, absolutely. So third parties can get access to the information. Now, there is a carve out. This is a really interesting thing from a strata perspective. Is our strata legislation specifically deals with defamation in a couple of places. Mm-hmm. So I think if you're looking at how, I suppose, government has recognised that strata communities can get caught up in the things we're talking about today, it's actually in the legislation. So, for example, we mentioned before, when someone puts a motion in, it's got to go on the agenda for the AGM. There's a specific protection under section 111A of the BCCM Act, not the modules, the Act, that says that when that goes in as a result of someone submitting it, then the committee itself and the individual committee members are not liable for anything defamatory that's in it. Now, of course, the carve out there is if the committee puts it in, it's defamatory, then you're in the zone. So, the government said people are entitled to put stuff in and you guys are off the hook if you do what you've got to do. And I think probably one of the other things that I don't think is necessarily understood, bodies corporates are going to have a range of insurance and they've got office holder insurance in place and all that sort of stuff. So quite often body corporate insurance policies don't cover defamation. Little trick there. So don't think that you can, as a committee member particularly, say something defamatory and then just refer it off to the insurer if there's a claim coming. Quite often it'll be a carved out thing. So you're on your own with that stuff. So be very, not that I think I've ever had a client say to me, well, I've gone and defamed someone, I know I'm insured for it, so I really don't care. But it's one of those things, you might think you're covered, but you're not.
Yeah, I think that's an excellent point, Frank. We'll put up a link in a moment of that section 111A of the BCCMA about what Frank was just talking about. Frank, we talked a little bit about records just a moment ago. So what happens if the body corporate, or say the committee or the manager for that matter, thinks that there is something defamatory contained in a record?
I'm glad you asked that. Because section 232 of the standard module, so again, people have the right to access body corporate records for payment of a fee, but the body corporate doesn't have to give people access to records that it reasonably believes are defamatory.
Yeah.
So again, to take away that element of publishing, goes on the record, but it can sit there. So from a body corporate management or administration perspective, and this, I suppose, it really, and these are the gaps that things can fall in from my end, is that body corporate managers, quite rightly, everything they get in, they save on the body corporate records, as they should. it's really important to make sure that everything that comes in does get read by someone. Because if, someone fires in that defamatory piece of correspondence, it can sit there unknown as a landmine for 6 months, and then the person that was allegedly defamed finds it and goes off their trolley. You're capable of carving those things out and parking them. So best practice from my perspective with stuff that comes in, anything that could remotely be defamatory, look at carefully, perhaps even get some legal advice as to whether it would be a reasonable thing to hide it away, and then find a way to park it somewhere where it's not easily accessible by third parties.
Yep.
But the legislation specifically allows for that to happen. And other than that, very rare for the legislation to allow a body corporate to keep private something that's come into the body corporate's records. Normally it's transparent, it's accountable, it's open, everyone's entitled to it.
So we'll put up a link to that section 232 information that Frank was just talking about, so you can sort of read that at your leisure. Okay, so and we'll also put up a link, I think, Frank, to a previous blog post you have authored on this topic as well, but just expands upon some of these points in a bit more detail. All right, so we've banged on and on a bit, and we've got a couple of questions there we'll hope to get to. Banged on a bit. So best practice. I guess, Frank, this is where we start to talk about how to avoid getting involved in it in the first place. Before we do that, though, I might ask you, do you reckon there's ever a moment when it's actually a good idea, or not a good idea, but it's warranted to proceed? Do you reckon there's a circumstance where it's warranted to proceed?
It'd want to be real. I'd say to be a rare one. And even Ben Roberts-Smith, primest example, because what happens in any defamation proceeding is that you want to cast doubts about the other person's credibility. So we've got, I think one of the media published something about Ben Roberts-Smith in relation to his service record. He objected to that, sued for defamation. And what that meant is that the defendant trolled through every single part of his previous history. And out of all of that has come a whole bunch of unsavoury allegations. So it's that, he who was without sin cast the first stone. It's got to be biblical. It happens all the time. Craig McLaughlin, there's another one. So it's just, it would have, because I really do think is that 6 months later, everyone's forgotten the pace of play that we're all operating under at the moment in terms of information that comes in front of us every day with newspapers and social media and radio and TV and Netflix and Foxtel and whatever else you're watching is enormous. It's sort of in one ear and out the other. And I think, if there was something that was particularly vile, I suppose there's probably some things you could say about me that would really get my goat. But, again, those clients say, you should see what this guy said about you, Frank. These guys are useless. They're not good lawyers. They're no good at whatever, mate. Go for your life. I don't care. Mm-hmm. That sort of stuff, just let it go. In theory, it is defamatory because it's not true. But no, mate, I really think, and talking all lawyers out of a job, you wouldn't quite say you got rocks in your head to commence one of these proceedings. It would be, it's a long, hard road because it sounds good in theory, but in practice, you're going to lose thousands of hours of sleep, hundreds of thousands of dollars if it goes the distance, and you might not win.
Might just make the situation worse in the process.
Exactly. All you got to do is keep republishing the same stuff that was said about you in the first place.
Yep, exactly. So what does that mean then? I think it's basics in Australia situation. It's, take a deep breath and pause. Do you really need to hit reply at that point? Do you really need to draft that email? Do you really need to say what it is that you are going to say?
24-hour rule, yet again.
Yep. By all means, draft the thing. It is so therapeutic, bashing it out, but just make sure that you save it into drafts. Don't accidentally hit send. That's always a bad move, that one. Reply all is definitely a big one in this sort of scenario. I think, Frank, it's also about knowing what it is you're talking about. So much of Strata is a bit mysterious and a bit difficult. Let's be honest. It is. Even practitioners, people like yourself, and then people like me, who deal in this stuff day in, day out, and have done so for you a lot more years than me. But even so, people who've done that sort of stuff, I still seek assistance, advice on the meaning of certain things in body corporate legislation? I'm assuming you do from time to time.
Absolutely. No, I had a question this morning. I emailed my litigators. Pop quiz, ladies, because they're all female. Here's the dot points. Here's the section. This is what I think, but I'm not 100% sure. What about you?
I get questions from people who've been in Strata decades. What do you think? What do you reckon this means? So I guess what are we saying there? It's very easy to fly off the handle and think that somebody has transgressed a particular provision of body corporate legislation. But my goodness, unless you are 100% sure of what you're talking about, you need to take care on that. Yeah.
Always confident, often wrong. Let's
try some of these questions, Frank. Jan, right up the top, thanks. Jan, not really a question, but a statement. Sent out emails to owners claiming bullying by the BC liaison person because his claims weren't documented in the minutes as they are defamatory. If your question's about minutes, minutes does not mean every word uttered needs to be documented. That's not what a minute is. Frank, what do you think?
No, I agree. And certainly there's a newsletter on this on our website from a while back, and I think we've done webinars on it as well, is that every piece of correspondence that comes into the body corporate doesn't need to get sent to all owners. So, and is someone saying that they're bullied defamatory? Maybe, but under the new regime, what's the serious harm that's flowing from it? So the reality is probably none. Well, yeah, no serious harm. Might be harm, but no serious harm. So that's the new regime. So it's sort of again, probably more than anything else with these things, these disputes that come up are about communication, controlling the narrative, and probably getting back in front of whatever's caused the issues in the first place to the greatest possible degree.
Yeah, well said. Thurston, I know you're a bit of a regular thing. Frankie, one for you, wondering if you're willing to speculate on this one. What a percentage of claims actually get to court and how long does it take?
I'd say a minority of them. I dead set probably the amount of times I've been contacted about defamation, probably even issued concerns notice and then run something the distance. I'd say less than 5% in terms of what I've seen across my desk. How long does the whole process take? Again, and this is the danger with litigation, is you're not in control of it because you're reacting to whatever the other side does and how long they take and then how long you take and all sorts of stuff. So it could be as long as probably 2 to 3 years, let alone the trial. So that is a lot of sleepless nights, to be perfectly honest, which is another reason not to do it.
Sam, thank you. If you send a motion before the end of financial year, but before a committee meeting held before the end of financial year, does the committee address that one or does it go to the AGM as well? Depends what you specified, Sam. Did you ask the committee or did you want it to go to the general meeting? They're two different things. So yeah, it really depends what you've asked and how you've asked it. Yeah.
Yep, agreed. So it's a question, framing the question.
Yep. Julia, thanks. I know a bit of a regular, Julia. Question there, demanding a lump sum within 14 days or will sue for defamation. I think Frank kind of covered that one a bit earlier about the set process. Yeah,
so you're not going to get sued for defamation unless you've been hit with a concerns notice, but it's not extortion in my mind to say, pay me X dollars or we will enforce our rights, our perceived rights or otherwise. That happens all the time in commercial matters. We think you're in breach of contract, you owe us 100 grand, give us that 100 grand or we're going to sue you. That's stock standard. What you can't do, and this is the thing that some people do, is from a criminal law perspective, say if you don't pay me X, I'm going to report you to the police for doing Y. That is a criminal act in itself. But in a commercial context, pay me X dollars or I'll go and enforce my rights, which might include suing you, is completely legitimate.
Thanks. And final one, Mr. SMB, is a distributed audio recording of a committee meeting considered possible defamation if there is alleged slandering going on at that
slandering, there's a word. Well, look, ultimately, again, we're back to the core elements of what is defamation. And that is a publication to a third party, which absolutely could be a recording, which identified someone, which caused serious harm. So absolutely, a recording which is sent to other people is no different to an email or a letter sent to other people, assuming, of course, you're part of the conversation, you've got the ability to record it lawfully and so on.
That's right. That's right. All right, we have reached the end of, that was a pretty involved discussion, but a pretty good one, I think. That is all the time we have for today. You can find all the notes and links, and there's a few from today's discussion at heinzlegal.com.au or YouTube and in the Heinz Legal channel. You can find me, that's Chris Hines, at Strata-Solve. Or sorry, I should say you can find me at stratasolve.com.au. You can find Frank Higginson at heinzlegal.com.au. Until next time, Frank.
Chris, thank you, everyone, yet again.
It's been good. Thanks, everyone. I'll see you next time.